if you've entered the country illegally, the general rule in immigration law is that you're not going to be able to apply for any benefit while here. Now, there have been exceptions to that rule. And so the thing that a careful immigration attorney must do and sit down with you is try to determine whether you qualify for any of those exceptions. But generally, if you've entered the country illegally, or if you've overstayed your visa and you're now out of status, you're not supposed to be here, your employer is not going to be able to help you get a work permit or get immigration benefits unless there is a special circumstance. Some of those special circumstances have been TPS, temporary protected status that's been identified for certain countries. There may be somebody who is 245I eligible, meaning that they had a petition filed for them long ago and they're now eligible to continue to try to pursue some sort of legal immigration option, and that legal immigration option also entitles them to apply for a work permit. So again, every case is different and it has to be thoroughly evaluated.
The employer may be able to help you, but it would have to have been a petition prior to April 30th of 2001, and that person would have had to have entered the country before December 21st of 2000 and not left. I mean, it's very difficult because once somebody is out of status, if the employer initiates a petition for that person, that may cause them to be put into removal proceedings. The other thing is, if you're out of status, then you can't change or adjust your status unless you do qualify under 245I, which would mean that petition has to be filed before April of 2001. So in most cases, an employer is not going to be able to help somebody who is in the U.S. illegally, especially if they're just starting that initiative at this time.